This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. You may know that I represent defendants who are accused of online... Oh, you know what? Do I need my... Yes, I need something. Hang on. You may know that I represent defendants who are accused of online file sharing and piracy in maybe not the greatest cases. These are cases where a plaintiff has seen file sharing activity via BitTorrent and only has an IP address to identify where the infringement is coming from. And then they file a lawsuit, get a subpoena, get the subscriber's name and address, and then from there, the courts usually let them interview the defendant or otherwise try and figure out who the defendant is based on who the subscriber is. And if you're starting to think, wait a second, that's not really a great way to do that. Yeah, that's my opinion too. I don't really understand how courts have allowed this to happen. I have gone to court several times arguing that an IP address is not a person, does not sufficiently identify a defendant above the level of mere possibility and into the realm of plausibility that is required by Federal Rule of Civil Procedure 8, I think it is. Well, Judge Ursula Ungaro from the United States District Court for the Southern District of Florida also has something to say about this. She says this cause, Strike 3 Holdings versus John Doe, is before the court sua sponte, on its own. The court is doing this without a motion from the parties or prompting from a party. The court has reviewed the pertinent portions of the record and is fully advised in the premises. On February 11th, 2021, plaintiff commenced the instant action alleging that an unknown defendant utilized an internet protocol called BitTorrent to infringe certain of plaintiff's copyrights. The 11th Circuit has held that a district court may dismiss a suit sua sponte or on its own for lack of venue after giving the parties an opportunity to present their views on the issue. In the present case, the court questions whether venue is proper in this district, venue would be part of jurisdiction, for the reasons herein stated, and accordingly provides plaintiff with the opportunity to show why this case should not be dismissed for improper venue. Plaintiff's complaint asserts that venue in the Southern District is proper under the applicable rules of jurisdiction because defendant resides and therefore can be found in this district and state, and because a substantial part of the events or omissions giving rise to the claims occurred in this district. Plaintiff used geolocation technology to trace the copyright infringement to an internet protocol address, IP address, located within this district. If I recall correctly, I don't know this specific case, but usually this plaintiff, Strike 3 Holdings, uses MaxMind to geolocate IP addresses. Plaintiff's assertion as to defendant's residency, therefore, seemed to be in large part based on the assumption that the geographic data results of IP address geolocation are valid and accurate. This strikes the court as possibly problematic after reviewing technical literature which suggests otherwise. See AF Holdings versus Rogers from 2013, due to the risk of false positives, an allegation that an IP address is registered to an individual is not sufficient in and of itself to support a claim that the individual is guilty of infringement. Among the many challenges presented by the internet is that the internet itself possesses no inherent mechanism for determining the geographic location of connected devices. While domain name system entries can include a location record, there is, to this court's understanding, no standard protocol to provide global location data which corresponds with an IP address. Furthermore, the size and complexity of the internet, coupled with its highly diffuse ownership and user base, provides no single repository or authority which could maintain such data. Instead, IP address geolocation technologies rely primarily upon active network measurements or alternatively databases of IP to location mappings. The former falls victim to inconsistent internet topology and incomplete information regarding this topology due to the internet's rapid and continuous expansion. Similarly, databases of IP location mappings tend to be rough and incomplete, also due to the internet's rapid expansion. Thus, despite the existence of geolocation software designed to approximate the geographical location of internet-connected devices, this court cannot rely solely upon plaintiffs' assertion that such technology was, can, or should be used for purposes of establishing proper jurisdiction and venue. This is particularly true in instances where the exclusive venue statute for copyright infringement controls and permits venue to be laid in the district where the defendant resides or may be found. For this court to rely upon the use of geolocation for establishing proper venue far more than mere conclusory statements by plaintiff is required. To allow this case to proceed in the Southern District of Florida, this court requires a showing of the precise methodology and technique employed by plaintiff in its use of geolocation to establish, to a reasonable degree of certainty, that the defendant may be found within this district. Additionally, this court recognizes that IP addresses are assigned to nodes connected to the internet, but are not necessarily representative of individual end node or end system devices. This would be true even your public IP address goes to a router, and then the router routes the information to the appropriate network through what's called network address translation. The router itself has the public IP address that everybody else on the internet sees, not your end device, not your phone, not your computer. So the IP address itself does not identify a specific device. And the judge notes there, in the hierarchical architecture of the internet, end nodes or end systems can take an extraordinary number of forms due to the increasing number of electronic devices which are digitally interconnected using one or more of the Internet Protocol Suite communication control protocols. Common examples include personal computers and smartphones, but may also include IP or Wi-Fi security systems, televisions, high-tech household appliances. It is imperative that one recognize that a publicly viewable IP address may represent nothing more than a router or gateway through which other devices connect. These devices, which may be part of a large intranet, may have their own private IP addresses that are not visible to users of the internet outside of the intranet to which the device is connected. Good on you, Judge. That was well written. These IP addresses are especially not representative of individual people. This court therefore requires that plaintiffs show that due diligence as well as due care have been employed in ascertaining that the IP address associated with the alleged tortfeasor is or was assigned to a system or node that can be used to reasonably calculate the identity of the alleged infringing party. Additional impediments to establishing identity include proxy servers. Of particular note are public proxy servers and common gateway interface proxy servers, intended in some instances to specifically provide anonymity to torrent seeds, peers in possession of all data belonging to a shared data file, and downloaders. Similarly, the possibility of IP address spoofing is of concern and should not be ignored. For example, an IP address assigned to a personal computer located within a single occupancy residence is far more likely to be fruitful than an IP address assigned to a publicly available Wi-Fi router at a coffee shop. Accordingly, it is hereby ordered and adjudged that plaintiff shall show good cause in fewer than 10 pages why this court may reasonably rely upon the plaintiff's usage of geolocation or other technologies to establish the identity of defendant, and that defendant may be found within this district. Mere speculation and conjecture will not suffice. Additionally, plaintiff shall show good cause as to why this case should not be dismissed sua sponte on its own for improper venue. Plaintiff shall respond to both questions no later than Monday, March 1st. Extensions of time will not be permitted. Failure to comply with this order will result in the dismissal of this case without further notice. Done and ordered in chambers this 16th day of February, Ursula Ungaro, United States District Judge for the Southern District of Florida. And I think the judge is on the right track there. I don't think any of these BitTorrent file sharing cases should be allowed to proceed without raising the knowledge of the identity of defendant above mere possibility. There is only a possibility that subpoenaing a subscriber will lead to a defendant. It is not plausible that getting an IP address and a subscriber assigned that IP address will lead to the actual person. There's an argument in the other direction, sure, but my perspective from the defense side, and my personal belief, even before I became an attorney, was that an IP address is just simply not enough to sustain a civil action. Maybe in a criminal case, a prosecutor should be allowed to investigate further, but in a civil case, it seems to be a lighter standard, an easier standard for the plaintiff, not a harder standard. It should be a harder standard to get in the door to meet the pleading requirements of Federal Rule of Civil Procedure 8. And then, once you've met the pleading standard, sure, use the civil standard for discovery, preponderance of the evidence, and disclosures, and adverse inferences, and all that. But you should have some kind of barrier before you get in the door and start, what I call it, harassing innocent subscribers who haven't done anything wrong, just so you can also get to the potentially liable defendant, who could really be anybody who uses the internet connection. Let me know what you think about that in the comments below. Should prolific piracy be stopped or reduced by allowing mass copyright enforcement? What if every plaintiff out there filed this kind of lawsuit for this kind of infringement? What if during the height of Game of Thrones popularity, which was one of the most popular, if not still the most popular, pirated content out there, what if HBO had sued everybody in the United States who pirated HBO's Game of Thrones? I think it would be mass pandemonium, and I think that the courts couldn't sustain it. And then maybe you'd suddenly see the courts say, wait a second, this isn't how it's supposed to work. But because you have one plaintiff doing this, it's somehow permitted. Hey, it's me, Leonard from the future. We now have a response to the order to show cause and some more interesting updates in the case. First, let's go over the order to show cause, and then we'll talk about the MaxMind database, and we'll see what happened next. Here is the response to the order to show cause filed by Strike 3 Holdings. The show cause order required the plaintiff to show cause that venue is proper and show that due diligence as well as due care have been employed in ascertaining that the IP address associated with the alleged tortfeasor is or was assigned to a system or node that can be used to reasonably calculate the identity of the alleged infringing party. This is part of the evidentiary standard, that the information will be able to reasonably calculate the identity or reasonably lead to discoverable information. So their response starts, plaintiff recorded rampant copyright infringement emanating from the IP address via BitTorrent over a period of several months. Although plaintiff knows that its copyrights were infringed, it does not know by whom because the protocol only reveals the user's IP address. Plaintiff is still able to glean some limited insights from just the IP address. It is able to identify with reasonable certainty the internet service provider which hosts the account. They use geolocation technology by MaxMind to trace the relative location of defendant's IP address. In this case, MaxMind determined that defendant's IP address traced to a location within this court's jurisdiction. Because of this, plaintiff knows which ISP it must subpoena for the pertinent information and what court has jurisdiction to issue such a subpoena, and it now seeks to use the IP address, the only identifying information it has access to identify defendant. Venue provisions are designed not to keep suits out of federal courts, but merely to allocate suits to the most appropriate or convenient federal forum. Whereas here, the court is concerned with plaintiffs' geolocation program's ability to accurately locate and identify the infringer, this issue dovetails with considerations arising from personal jurisdiction, which is different from venue. For purposes of copyright litigation, venue is proper if in personam jurisdiction is proper. Plaintiff is, in essence, seeking jurisdictional discovery. 11th Circuit precedent holds that a plaintiff who chooses a federal forum should be given the opportunity to discover facts that would support allegations of jurisdiction, and ordering dismissal without affording the plaintiff any opportunity to proceed with reasonable discovery is premature and an abuse of the court's discretion. Plaintiff must be given an opportunity to develop facts sufficient to support a determination on the issue of jurisdiction. Here, plaintiff's limited expedited discovery request to defendant's ISP serves several ends. Not only does the information allow plaintiff to identify and serve the infringer, it confirms that jurisdiction and venue are proper. Geolocation technology like MaxMind creates a good faith basis that jurisdictional discovery will confirm that defendant resides in or can be found in this district, they say. Limited jurisdiction discovery is appropriate where the information plaintiff seeks, if it exists, would give rise to jurisdiction. It is well established that a qualified right to conduct jurisdictional discovery is recognized in the 11th Circuit, meaning that a district court abuses its discretion if it completely denies a party jurisdictional discovery. And an abuse of discretion, if it is true that that's an abuse of discretion, that's an appealable issue, and so an appeals court would refer the case back to the lower court and order them to allow the discovery, assuming that that's accurate. To obtain jurisdictional discovery, a plaintiff must have at least a good faith belief that such discovery will enable it to show that the court has personal jurisdiction over the defendant. Geolocation services may be used to estimate the location of internet users based on their IP addresses. During its pre-suit diligence, plaintiff inputs defendant's IP addresses into MaxMind to determine the relative location of a defendant. A showing that the internet account associated with an IP address that is allegedly engaging in infringing activity is located in the district is sufficient to establish prima facie personal jurisdiction over the alleged infringer. That's going to be the basic case. Prima facie case is your basic case. So they're saying that they can establish the basics of personal jurisdiction. That's a presumption that's probably rebuttable by further discovery. If the MaxMind information disagrees with the actual location of the party, then that party can definitely bring that up in court. The trouble I have as a defense attorney is when it's wrong, it costs the defendant money, it costs them time, and it costs them stress. Sometimes a defendant might be misidentified, or a subscriber might have to respond that they're not located there, and that's something they have to do. That's a thing they have to pay an attorney for to do. So it can be burdensome, I would say unduly burdensome, on the defendant to have to respond in the wrong court and end up with extra fees for something that was plaintiff's mistake. As other courts have observed, these services provide a good faith basis to believe a putative defendant may be a district resident if a geolocation service places her IP address within the district. Indeed, some courts even confirm an IP address geolocation on their own using such generally available services like iplocation.net. Here, a reliable geolocation technology is proper in forming plaintiff's good faith belief that jurisdiction and venue are proper in this district. MaxMind is a reliable technology. Then they go on to talk about how MaxMind is a reliable technology. According to MaxMind, its IP address tracing service is approximately 95% accurate in the US. Its basic geolocation tracing service is 99.8 accurate on a country level. So nearly 100% of the time they will get the country right. I'm not convinced. 90% accurate to a state. Okay, we're getting closer, but still, a state is not going to get you the proper district unless there's only one district, like the District of New Jersey or the District of Maryland. Its basic geolocation tracing service is 87% accurate on a city level for the US within a 50-kilometer radius. Hey Google, what's 50 kilometers in miles?
50 kilometers is equivalent to 31.069 miles.
So 31 miles radius. However, MaxMind's GeoIP2 Precision Web Services, which is the service used by plaintiff here, is MaxMind's most accurate data at city postal code level, geolocating 7% more IPs. I think that's 7% more of the 87%, not 87 plus 7%, but rather, whatever 7% of 87 is, and then add that to 87. And 3% more IPs to the correct city. That still seems not accurate enough, in my opinion, to make sure that we don't accidentally prosecute innocent people, but okay. In other words, MaxMind is akin to services that offer a reverse lookup in the white pages of a phone book using the caller's telephone number, but instead of searching for a person's name with a telephone number, they're using an IP address. Importantly, and here's kind of the fun part, if you find something like this as an attorney, you just have to use it. On May 19th, 2015, this court held a hearing regarding the accuracy of this exact technology and concluded that the court is satisfied that the geolocation technology used here to pinpoint the subject IP address to the Southern District of Florida is reliable. And I did look it up. It was a different judge, but it was the same court, Southern District of Florida. Courts across the country are in accord and consistently find that plaintiff using MaxMind has demonstrated a prima facie evidence of proper venue and personal jurisdiction allowing expedited discovery. When plaintiff only knows defendant's public IP address, this is sufficient to allow plaintiff to reasonably calculate the identity of the alleged infringing party. Plaintiff's burden at this stage is one of plausibility, not certainty. And as far as I know, that's correct. Bell Atlantic v. Twomley and Ashcroft v. Iqbal, our landmark or hallmark jurisdictional cases, they say that you must raise the level of certainty above mere possibility into plausibility, but you don't need certainty. That is correct. And then they argue that it is plausible that files downloaded using a particular IP address were downloaded by the subscriber of that address. I disagree. I think it's merely possible. I don't think it's plausible that the subscriber does it. We have no way to calculate the plausibility of the subscriber being the infringer. Very often there's more than one person using an IP address. So it's only plausible if the subscriber is the only person using the internet. And there could be unknown people using the internet too. If someone has guessed your password, if you have a default Wi-Fi password, someone might have had access to your network at some point, like through WPS or something like that. If someone has cracked the password, which I'm not sure how easy that is to do with modern WPA, was it 2? I think it is. It's harder. It used, web keys can be broken pretty easily now, but not sure about modern technologies. While the subscriber to an internet service is the most plausible individual to use the service, plaintiff nevertheless will use the name and address retrieved from the ISP to further investigate the identities of anyone plaintiff can deduce had consistent access to the IP address. If plaintiff determines that it does not have sufficient cause or evidence to identify the infringer, for example, if the ISP has destroyed the relevant logs or if the investigation turns up inconclusive, plaintiff will dismiss the claim. If, however, the investigation uncovers sufficient evidence to determine the subscriber is the infringer or that some third party is the infringer, plaintiff will amend its complaint to single out that individual and continue prosecuting its claim. As a result, and particularly because plaintiff has such a limited ability to identify infringers hiding behind online anonymity, obtaining the IP addressee's information is the logical first step in identifying the correct party. In sum, the web of technology shielding defendant's identity online both necessitates plaintiff's request for limited discovery and supplies the good cause for it. Plaintiff starts with the IP address used by the infringer to download and distribute its motion pictures, and through its pre-suit diligence, plaintiff determines which ISP possesses the relevant information and uses MaxMind to geolocate the IP address, and what court has proper jurisdiction and hence proper venue to endorse plaintiff's limited subpoena. Finally, when plaintiff has the name and address of the subscriber, it performs another diligence search to establish corroborating evidence that singles out the infringer. Under these circumstances, plaintiff's subpoena is entirely proper. So they filed that on February 28th, which was one day before it was due, I think. And that's very interesting because when I go to the support center for the GeoIP2 MaxMind technology, it says it is 68% accurate in the US within a 50-kilometer radius and then 7% more. I think that's different than the 87% accuracy within a 50-kilometer radius that they cited here. I'm not sure who is right there, but this page definitely says 68% plus 7%. And so if you think about a location here, if you geolocate a IP address to Springfield, Massachusetts, you could really have something in the District of Massachusetts, or maybe in a New York district here, like the Northern District of New York. You could have something in Connecticut. You could have a little bit of Rhode Island. You could even have a little bit of New Hampshire. So, that's not really, to me, the greatest way to identify defendant's location. But wait, there's more. Shortly after filing that response to the order to show cause, defendant, who is so confident in its case, voluntarily dismissed the case. This is a notice of voluntary dismissal, hereby gives notice that its claims in this action are voluntarily dismissed with prejudice. With prejudice would mean that the claims are extinguished and cannot be filed again, but then they filed this notice of errata saying that they mean to dismiss without prejudice, and then the judge grants the order of dismissal without prejudice, and so all future hearings and deadlines are canceled, all pending motions are denied as a moot, and it is done and ordered. So the case is over. I guess they decided they don't like Judge Ursula Ungaro's scrutiny. I don't know. You can take that for how you take that. I take it to mean that they're so confident in their case that they had to dismiss it. I think it's more like they have so many other cases that are going fine that why, the squeaky wheel gets the grease. If the judge has even a minor disagreement with them, they'll just dismiss the case and go find another judge, or just forget this IP address and move on to the next IP address. This is a company that has hundreds of these cases going at any given time. There is even the Florida Pure Bill of Discovery thing where they have filed for about 50 to 100, sometimes over 100 IP addresses in one Florida state court, county court action. And then they'd only have to pay one filing fee for that if I have my information correct. So yeah, that's what's going on. And I think it's a really interesting exploration into the way companies are trying to find infringers through the internet when they can only identify them by IP address. I've even had clients who have asked, well, what piece of equipment are they saying that was used? And they don't have that. The plaintiff, according to this, only has the IP address. There is no MAC address, no machine address code to tell you which piece of equipment, which there wouldn't be. I mean, the MAC address is a different layer of the OSI networking model. It's used to go hop to hop from equipment to equipment. The IP address is the end destination until you get to routing equipment, like network address translation equipment, your basic consumer router that would then translate the IP address and packet information into an actual destination behind the public IP address. So if they only have the IP address, then they don't even have the end piece of equipment. They only have the customer premises equipment from the ISP. So let me know what you think of that in the comments below. I think that's a really interesting conclusion to this case. We had the plaintiff show cause why they should be allowed to proceed with the case and then immediately dismiss the case, which is, I think that speaks for itself. Thank you for watching. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel here on YouTube. You can also find us on Floatplane and on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Our channel is community supported by your monthly financial contributions on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Thank you to the following $50 plus supporters in the month of March: Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Andy, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Brandyn Abel, Torpedan, Cassandra Curran, Sovereign Tittizen, ShadowTycho, RDHDragon, and Earthbound Star. And thank you as well to the $5 plus supporters who are scrolling on your screen. I hope everyone has a great week. I will see you in the videos that drop. I love you all. Bye.
not a cat.